Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Hey, oftentimes the purpose of us doing videos here at Washington Gun Law is to educate you, the lawful and responsible gun owner nationwide. But occasionally, once in a blue moon, we get a topic that comes along that we think is a really good precipice for discussion and debate about things that affect all of us and could affect all of us as we near our end of life. Now, there is a terrible story coming out of Florida that we're going to get you up to speed on, but I think it's a good opportunity to have a discussion about something that could matter to many of you somewhere down the road. So today, let's have a really important discussion about, does this Florida woman deserve to go to prison for shooting her husband? Okay, so the issue we are talking about today is a news story that broke last weekend out of Daytona Beach, Florida. But last Saturday at Advent Health in Daytona Beach, Florida, 76-year-old Ellen Gilland shot and killed her husband while he was in hospice care at Advent Healthcare. She shot him, as reports say, in relatively close range directly in the head. Now, it would seem at first glance that this is a cold-blooded murder. However, there is much, much more to the story, and I want to share that with you because the now deceased Mr. Gilland, unfortunately, was terminally ill, in a tremendous amount of pain, and given only a couple of months to live. In addition, Mr. and Mrs. Gilland had made a pact approximately 3 weeks ago that they would commit a murder-suicide because he simply was in too much pain to continue to go on, and she simply could not fathom going on in life without him. As the plan originally was hatched, the plan was to be that Mr. Gilland would shoot his wife and then turn the gun on himself, ending his life. Unfortunately, by the time it came around to actually execute the plan, Mr. Gilland was so weak that he could not properly manipulate the firearm, so it was Mrs. Gilland who shot her husband and then simply just did not necessarily have the courage, the guts, or whatever you want to call it, to go through with the second part of the plan, which was turn the firearm on her. Now, a long standoff ensued for several hours. Police eventually took Miss Gilland into custody. Now, she is being held in jail on no bond on one count of premeditated murder in the first degree and 3 more counts of aggravated assault with a deadly weapon. Obviously, if convicted of these offenses, I'm not certain what the penalty time is in Florida, but we know that Florida does not mess around with this stuff. And obviously, with Miss Gilland's advanced age, any jail sentence in all likelihood is tantamount to a death penalty. So the question or questions and topics that I want to see you all discuss in the description box below is does this woman deserve to go to prison for ending the life of her husband at his wishes when his life was nearly over and he was in absolutely unimaginable pain? And that begins to bring up a topic that we rarely, if ever, discuss here at Washington Gun Law, and we may not ever discuss again, but that is medically assisted suicide or medically assisted euthanasia. Now, in almost all states in the United States, a doctor assisting in end-of-life procedures is against the law. In fact, they call that in many states murder. However, there are multiple states in the United States that have now created some statutory scheme to allow patients to end their own life. Washington State, my home state, for example, many, many years ago, passed a bill called the Death with Dignity Act. And the way that bill works, or that law works, is if a patient is terminally ill and there is medical documentation to establish that, and that patient has less than 6 months to live, they can apply not once but twice in writing with appropriate waiting periods where they can then be given lethal doses of medicine that will essentially end their life. However, the doctor does not assist in administering that medicine. It is the patient or somebody that the patient appoints that will assist in that. Now, there are lots of safeguards, and you will notice that the only method by which a person can legally end their life in the state of Washington is through medicine. There is no statute in Washington state that says a spouse can just go ahead and run a piece of lead through a person's forehead to end their life. Now, Washington is not alone. There are several states that actually have some form of medically assisted or state-authorized end-of-life procedures. They include Oregon, Washington, the District of Columbia, Hawaii, Maine, Colorado, New Jersey, California, and Vermont. And in each one of those states, there is legal procedures in place for a terminally ill patient to engage in end-of-life medical treatment to terminate their life and end what is obviously some unimaginable suffering. But you'll also notice that the state of Florida does not have this law. And according to the news reports, and there were multiple news reports about this event, apparently this is not particularly uncommon in the elderly community. Now, that begins to raise all sorts of issues here. The first, of course, is what are we doing to manage end-of-life care such that patients now feel the need to go out and buy firearms and violently end their lives in the fashion in which this killing was committed? And unfortunately, every one of us has probably been touched by some tragic events in our lives where a loved one was stricken with a terrible illness and it took them a very long time to die. And unfortunately, down the stretch run of their lives, they were in absolutely unimaginable suffering and pain. We all have stories like that, and they leave indelible marks on our lives. So what is the correct solution here for someone like Mr. Gillen, who did not have very much time to live? The quality of his life was all but taken from him. He was in absolutely untreatable suffering and pain. And Miss Gillen simply just did not want to see her husband suffer like that anymore. What should states do in that situation? Should there be a push for some type of federalized or regulated state-assisted end-of-life care for people who were in Mr. Gillen's position? Or do you believe that there is so much sanctity in human life that we have to let human life end as our Creator intended it and not to accelerate that fashion? I am candidly torn on this issue, and I have a lot of amazing, well-educated, very bright and sharp, lawful and responsible gun owners out there, and I am interested to hear what you think about this. Do you think Miss Gillen should go to prison? Do you think that she should be convicted of any crime? What do you think should happen to her? And what do you think we can do as a country to make sure that incidents like this do not continue in the future? Listen, you may have more questions about this issue or anything else related to your Second Amendment rights. And if you do, remember, you can always contact us at WashingtonGunLaw.com, or you can call us directly at 425-765-0487. Now, in the meantime, let's remember, part of being the lawful and responsible gun owner, like we talk about all the time here at Washington Gun Law, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching. Stay safe.